What's going on? Awesome, beautiful, wonderful, intelligent, creative, ye be gods, YouTubian people. And I haven't said this one in a while. I want you guys to have a great day. To all the people out there watching my channel, do not give up on yourselves. Continue to keep going. Fight the good fight. If you have to stop for a moment and dust off, gather yourself. As the old people say, get your feet right. Get your feet under yourself. Whatever you have to do, whoever you have to become mentally, become that person. You don't have to forgive your family, but you should. You don't have to hang out with your family, but you should. I would argue to say that as a bare minimum, you should at least throw out a olive branch and then keep stepping and do what you need to do. Bury those hatchets, let the stuff go. Probably mad at your ex or whatever else, let it go. Use that energy, free yourself. First of all, it feels great to free yourself, to feel yourself, to free yourself of negativity, because where you're going, if you truly want to get in life ahead, you need to be as light as possible. So get rid of that negativity. Let it go. Let it go. Bury the hatchet. You'll be surprised how much farther you'll get when you're not carrying the weight of negative people with you. That being said, let's get going. Once again, guys, don't forget to hit that bell, like, subscribe. I want to thank you guys for checking in with the Wolf. Woo, woo, woo. We are going to be talking about when a police officer gets sued. Okay, so let's take a look at what was written up on them. So credit goes to litigation roadmap for this. This is out in the public domain. So we are going to listen in on an overview of what goes on. This happens to be in Maryland. So the A6, my young cousin out there, this goes out to you.
An overview of police misconduct litigation in Maryland. Lawsuits filed against law enforcement officers, collectively referred to as police officers in this publication, are an established part of the legal landscape. Although police officers generally have broad powers to carry out their duties, the United States Constitution, state constitutions, and other laws place limits on the actions police officers may take in enforcing the law. The videotaped beating of motorist Rodney King in Los Angeles more than 25 years ago shockingly illustrated to the nation that police officers can cross the line. Subsequent events have etched images of police use of force, including fatal shootings, into the nation's consciousness. Moreover, the continuous recording of police officers by citizens has created an atmosphere in which lawsuits against police officers have become the rule rather than the exception. Those who claim to have been victimized by police officers have ample recourse available under both federal and state law. One of the primary purposes of civil rights laws is to protect citizens from abuses by government, including police misconduct. In addition to the compensatory and punitive damages and other forms of relief available to plaintiffs, federal civil rights laws allow for the recovery of attorneys' fees, providing a further incentive to sue. Police misconduct litigation is vastly different from the criminal justice system with which police officers are most familiar. In police misconduct cases, not only police officers, but their supervisors, agencies, and local governments can be defendants. Cases can be time-consuming and take years to resolve. Settlements can leave officers embittered and judgments can damage careers. This publication focuses on what happens when police misconduct lawsuits are filed. The objective is for police officers to be able to answer the most common questions related to lawsuits. What can I be? Image courtesy of Jeffrey Sowers via commercialphoto.com. 2. Sued for? What do I do if I am sued? What types of damages or other relief can I be sued for? Will I be assigned an attorney if I am sued? What will occur during the litigation? Will I be covered in the event a judgment is entered against me? The civil litigation process should not be alien to police officers. Officers must and should have a basic understanding of the process in which they have so much professionally and personally at stake. The exercise of police powers and allegations of police misconduct. The exercise of most routine police powers, i.e., investigatory stops and detentions, arrests, searches and seizures, the use of force, and custodial interrogations, can give rise to a lawsuit alleging police misconduct. The sources of legal claims of police misconduct. A. The federal sources. The source of police misconduct claims under federal law is found in the United States Constitution. Lawsuits alleging federal constitutional violations against state and local police officers are brought pursuant to federal law, 42 U.S.C. Section 1983, popularly known as Section 1983. Section 1983 establishes a cause of action for any person who has been deprived of rights secured by the United States Constitution or laws of the United States by a person acting under color of state law. In order to prevail on a Section 1983 claim, a plaintiff must prove that 1. The conduct was committed by a person acting under color of state law and 2. As a result of this conduct he or she was deprived of rights, privileges, or immunities secured by the Constitution or the laws of the United States. The first requirement is known as the state action requirement. The plaintiff must prove that the police officer acted with the appearance of legal power, even though the conduct may have violated the law. An example would be a police officer making an arrest, which he or she is empowered to do, but lacking probable cause to do so. Most commonly, police officers are sued under Section 1983 for alleged violations of the Fourth Amendment, unreasonable search and seizure, which governs detentions and arrests. The 14th Amendment guarantees against deprivations of life, liberty, or property without due process of law, and First Amendment, protection of freedom of speech and assembly. B. The state sources. There is no state version of Section 1983. Police officers can be sued directly under the Maryland Constitution, or more specifically, the Maryland Declaration of Rights. The Declaration of Rights is a series of articles establishing certain rights for people in Maryland. These include guarantees similar to those found in the first 10 amendments to the United States Constitution, commonly referred to as the Bill of Rights. Examples include freedom of speech, Article 40, guarantee of due process, Article 24, and prohibition of unreasonable searches and seizures, Article 26. In addition to claims under the Declaration of Rights, police officers can be sued under Maryland's common law, judge/court-made law, for an array of torts. Tort means wrong and, unlike a criminal case, which is initiated and managed by the state, a tort suit is a civil action brought by a plaintiff against a defendant. Common law torts include assault, battery, false imprisonment, false arrest, malicious prosecution, defamation, trespass, and intentional infliction of emotional distress. 3. The lawsuit. The lawsuit, complaint, will be drafted by the plaintiff, or, if represented, his or her attorney. The lawsuit will identify the defendants and set forth allegations, both factual, a description of the events giving rise to the lawsuit, and legal, the specific claims. specific claims, or causes of action, are divided into counts, e.g., Count I, Section 1983, Fourth Amendment claim. Count 2, violation of Declaration of Rights. Count 3, false arrest/false imprisonment, and Count 4, assault and battery. Claims for relief can be for compensatory damages, punitive damages, and/or equitable, most commonly injunctive, relief. A jury trial may or may not be requested. A. The statute of limitations. In Maryland, a civil action must be filed within 3 years from the date it accrues. Accrual in the context of police misconduct claims generally means the date of the occurrence. The same limitations period applies to claims under Section 1983. B. Personal versus official capacity claims. Under federal law, police officers can be sued both in their personal and official capacities. Under Maryland law, official capacity suits are not recognized in this context. 1. Personal capacity claims. A personal capacity action is just that, a suit against a police officer for his or her alleged wrongdoing. Under federal law, personal capacity claims are not limited to the officer who allegedly committed the wrongful act. Other forms of personal capacity liability are recognized, namely bystander liability and supervisory liability. Bystander liability is a theory of liability fashioned under Section 1983 that exposes officers, including supervisors, to personal liability, including punitive damages. To succeed on a theory of bystander liability, a plaintiff must demonstrate that a police officer, 1. Knew that a fellow officer was violating the plaintiff's constitutional rights, 2. Had a reasonable opportunity to prevent the harm, and 3. Chose not to act. Bystander liability claims are most common in excessive force cases. It is a claim that is difficult to prove, but, depending on the circumstances of each case, puts the officer as bystander on the same footing as the alleged wrongdoer. Supervisory liability is yet another theory that exposes supervisory officers to personal liability, including punitive damages. Supervisory liability requires that a supervisor had actual or constructive knowledge that his or her subordinate officer was engaged in conduct that posed a pervasive and unreasonable risk of constitutional injury to citizens, and that the supervisor responded with deliberate indifference to or tacit authorization of the alleged offensive practices, such that there was an affirmative causal link between the supervisor's inaction and the particular constitutional injury suffered by the plaintiff. In other words, the liability of a supervisor is premised on a recognition that supervisory indifference to or tacit authorization of a subordinate officer's misconduct may be seen as 4. A cause of the constitutional injury sustained by the plaintiff. The bottom line is that a supervisor cannot turn a blind eye to the misconduct of subordinates. By doing so, he or she is potentially exposed to personal liability. 2. Official capacity claims. Under federal law, an official capacity action may proceed only to the extent that the police officer's conduct implements governmental law, policy, or custom, i.e., the deprivation underlying the Section 1983 claim is caused by a statute, regulation, policy, or custom of the governmental entity that the official was implementing. An official capacity action is really an action against the governmental entity, of which the police officer was merely an agent. Examples of policy and custom claims include failure to train, failure to discipline, failure to supervise, and condoning the use of excessive force or unlawful arrests. What relief can be requested? A plaintiff can sue for compensatory damages, punitive damages, injunctive, and declaratory relief. Compensatory damages, a sum of money awarded in a civil action by a judge or jury to indemnify a plaintiff for the particular loss or injury suffered as a result of the unlawful conduct of a defendant. Punitive damages, a sum of money awarded in a civil action by a judge or jury in addition to the award of compensatory damages. Punitive damages are intended to punish the defendant and discourage others from acting in the same manner in the future. Local government employees, including police officers, are liable for punitive damages under state law if they acted with malice, hatred, ill will, improper motive, or under federal law if they acted with reckless or callous indifference to the plaintiff's federally protected rights, as well as when their actions were motivated by evil motive or intent. Because it is the personal conduct of the officer that is alleged to be wrongful, punitive damages are permissible in a personal capacity action, but the plaintiff may look only to the personal assets of the police officer, and not to the local government, for the recovery of any.
So like I told you, police officers who watch my channel, if you mess up, they can go after your personal stuff, your house, and anything that your wife has or your husband, because it's joint, your kids' bank accounts. It ain't funny when it comes to the money. See, some of y'all think I'm out here after y'all or against y'all. Now, obviously, my friends and family who are cops, they know this is not true. But I get it. You guys don't know me. And your bosses tell you, oh, this guy out here, he's trying to muff you up. Nope, not true. Like I said, the information on my videos will help you guys too, because you guys are being scammed and ripped off as well. Now, to the dick cops out there and the ones who don't know the law, screw you. But even if you guys came to me, I would still help you as well, because that's what's right. Because you have the right, you have the liberty and to protect your private capacity. And if you come to me for a consultation, I'll show you how to protect your assets and whatever else too.
Any punitive damages award. Injunctive relief, injunction, a legal remedy that may be sought in a civil lawsuit, in addition to, or in place of, monetary damages. Rather than offering money as payment for a wrong in a civil action, injunctive relief is a court order for the defendant to stop a specified act or behavior. In a police misconduct lawsuit, injunctive relief would be pursued against the local government police agency as opposed to an individual officer.
In other words, when you hear people talk about injunctions, they're saying, you know what, I don't want money. I want your police station to never bother me again. Unless I need something from you, leave me alone.
Officer. Declaratory relief is a binding judgment from a court defining the legal relationship between parties and their rights in the matter before the court. A declaratory judgment does not provide for any enforcement, however. In other words, it states the court's authoritative opinion regarding the exact nature of the legal matter without requiring the parties to do anything. Attorney's fees are available to a plaintiff who prevails in a Section 1983 claim. Attorney's fees are awarded in addition to any other recovery a prevailing plaintiff receives. 5. Where the lawsuit may be filed. Police misconduct lawsuits may be filed in federal or state court. To file in federal court, i.e., the United States District Court for the District of Maryland, there must be at least one claim that arises under federal law, such as a claim under Section 1983. State law claims are often included in complaints filed in the United States District Court. Section 1983 claims can be filed in state court. If a lawsuit filed in state court includes a claim under Section 1983, the defendants can, if they all agree, remove the case to the United States District Court. After the lawsuit is filed, the clerk of court will issue a writ of summons for each defendant. Service of the writ of summons, complaint, and any related papers will then be made upon each defendant. Service is effected in various ways, including service by private process server, sheriff, state court, U.S. Marshal, federal court, and certified mail. Problem. commonly arise when someone without authority accepts service for a police officer or signs for and receives restricted or certified mail addressed to individual officers without express permission to do so. Police officers can avoid these problems by making it known to the chief of police or sheriff, in writing, that no other person has express or implied authority to accept service of process on their behalf or to sign for and receive restricted and/or certified mail deliveries addressed to them individually.
So what are they saying here? Let's back it up. They told you a lot here. So what they're saying is if a cop, and this goes out to you cops out there and the rest of you, because I know you guys watch, if you don't want to be sued, in order to be sued, you have to be served properly. Which means that if a person, if they find out where you live, they're going to serve you at your house. Because all the cops have to live within the area in which they are officers, which are most city laws and within the city limits. A simple property search can find you. All they need to know is your name, and that's part of the public. Then they do a property search and find out your address, and they serve you there. Maybe your wife or kids or somebody else will accept it. You got served. If they can't find you there, they go to your work because they know where you work at. Somebody accepts it there, you've been served. Even though maybe they weren't supposed to, they took the mail in and gave it to you. You got served. So what are they telling you? So here they're telling the police officers to make sure your chief of police doesn't accept at the mailing distributions location any of those documents because they don't want to be served. They don't want you to get sued. So what do they tell you? So they went and told you that if you don't accept the mail at your house, they can't serve you. But see, here's what the courts do. The courts go ahead and do it anyway and get a default judgment. So you can run if you want to, but then they're just going to go ahead and get a default judgment because you didn't respond. Now, that can be contested to say, well, I was never served properly. I didn't know anything about it. So how are you going to get a default judgment when I wasn't there to receive it? But then that's something in itself you have to argue. And as you're arguing, you're most likely going to then make a fatal flaw. You're going to put your address on the envelope when you communicate with them. I've made this flaw myself. Now, here's what you should do. You can either use a out of country P.O. box or a P.O. box. Foreign address, whatever, or nothing at all. Merely make your statement. It has come to my attention through a third party that there might be something there with my information on it. For the record, I never received any notification. I was not served. And that is all. And obviously, there's other information you can put in there, which is why we do consultations. But you get my drift. Let's go on. I got more to educate you guys on, so let's keep it moving, moving.
Individually. Individually. When the lawsuit is served. Since response times are triggered by service of process, it is of critical importance for police officers to retain all documents served, including the mailers, envelopes, etc., in which the writ of summons, complaint, and other papers were contained. Immediately notify the chief of police or sheriff when and how you were served with the complaint. Make sure that all departmental protocols concerning service of process are followed. Follow up with the chief of police or sheriff to make sure that the paperwork has been forwarded to the appropriate person, department, or entity. Failure to take action could have serious consequences, including the possibility of a default judgment being entered against you.
Yay!
Ensure that your personal contact information on file with your department is current. Cooperate with your assigned counsel. Failure to cooperate can result in serious consequences, including the withdrawal of your defense and the loss of insurance coverage.
There you go.
Civil litigation is much different from the criminal justice system with which you are intimately familiar. It is far more detailed and time-consuming. Remember that you are often the best source of information concerning the events giving rise to the lawsuit. Begin assembling all documents, paper and/or electronic, that is in your or your agency's possession, and reflect on the events to refresh your recollection of them. 5. Where the lawsuit may be filed. Police misconduct lawsuits may be filed in federal or state court. To file in federal court, i.e., the United States District Court for the District of Maryland, there must be at least one claim that arises under federal law, such as a claim under Section 1983. State law claims are often included in complaints filed.
Sorry about
5.
that. It must have backed up.
Where the lawsuit may be. Where the lawsuit may be. 5.
One moment, please, my good people.
The insurance decisions, coverage and indemnification. Once the chief of police or sheriff has notified the appropriate municipal or county officials, including the municipal or county attorney, of the lawsuit, it is expected that the appropriate official, usually the risk manager, will place the local government's insurer, LGIT, commercial carrier, or self-insurance fund manager, on notice and transmit copies of all papers served upon the officer. At LGIT, the Claims Services Department will review the lawsuit and determine if there is an obligation to defend, duty to defend, and potentially to indemnify, duty to indemnify. The decision to defend and scope of employment. The duty to defend is the insurer's obligation to provide an insured with defense to claims made under a liability insurance policy. As a general rule, an insured need only establish that there is potential for coverage under a policy to give rise to the insurer's duty to defend. Therefore, the duty to defend may exist even where coverage is in doubt and ultimately does not apply. The decision to defend essentially is tied to the allegations in the complaint. For example, if it is alleged in the complaint that the police officer made an unlawful arrest in performance of his or her duties, LGIT will provide a defense for the officer sued. In other words, the decision and duty to defend generally arises when it is alleged that the officer acted in performance of his or her duties as a police officer, i.e., within the scope of employment. There are many considerations relevant to whether an employee's actions were within the scope of employment. The general test for determining if an employee's tortious acts were within the scope of his or her employment is whether the acts were in furtherance of the employer's business and were authorized by the employer. The Maryland Court of Appeals described it this way in 1991, when an employee's actions are personal, or where they represent a departure from the purpose of furthering the employer's business, or where the employee is acting to protect his own interests, even if during normal duty hours and at an authorized locality, the employee's actions are outside the scope of his employment. Sawyer v. Humphreys, 322 MD 247, 1991. Here are just two examples of Maryland appellate courts speaking to scope of employment in the context of police misconduct litigation. Plaintiff concedes that the scope of an officer's employment does not encompass the rape of a citizen and that neither the Local Government Tort Claims Act nor the first paragraph defining an insured in the county's self-insurance regulations require the county to pay the tort judgment against its police officer. Wolf v. Arundel County, 374 MD 20, 30, 2003. Defendant's actions after the shooting, calling 911, identifying himself as a police officer, putting on his police badge, and filing reports, do not show that he was acting within the scope of his duties as a police officer when he shot the two delivery men in his house. Clark v. Prince George's County, 211 MD App, 548, 578, 2013. The decision to indemnify. Indemnification is the obligation to pay another for a future liability that might arise. This usually includes coverage of liability in the form of actual damages or losses, such as having to pay a third party. In addition, such provisions often include coverage for liability in the form of defense costs, i.e., the cost of dealing with. 7. A third-party claim, even if there is no ultimate liability to the third party. Punitive damages are generally excluded from coverage. Legit's practice is to promptly notify defendants in writing of its decisions concerning defense and indemnification. The reasons are set forth fully, and any denials of defense or exclusions or other limitations on indemnification. Any reservation of coverage, essentially deferring final decision until later stages of the litigation, including the entry of judgment, must be fully explained in writing.
All right, so now what they're going to talk about here is defending the lawsuit. So these are the ways that they're going to try to get the officer out of the lawsuit. Okay? So now they're about to tell you, hey, we're going to defend you. We're going to pay your claim. We got you. But here's how they're going to have a defense against you. Now, some of what they're going to say here is stuff that you can use for yourself, or stuff that you can use to combat what's going on, to make sure that they don't use one of these techniques against your lawsuit. Okay? So let's hit it.
Writing. Defending the lawsuit. Once the insurer assigns counsel, the defense of the lawsuit begins. Your attorney will contact you and establish the line of communication that must remain intact throughout the litigation. Your attorney will explain his or her approach to the case and what is expected from you in the way of cooperation. Your active cooperation and participation throughout the litigation will be critical to your defense. Raising defenses. Defenses are raised through an answer or a preliminary motion to dismiss. An answer is a written pleading filed by a defendant to respond to a complaint filed and served upon that defendant. An answer generally responds to each allegation in the complaint by denying or admitting it, or admitting in part and denying in part. A motion to dismiss is filed before an answer and challenges the legal sufficiency of the complaint. It does not test the ultimate merits of the case. There are different reasons for filing a motion to dismiss. Some include a lack of subject matter jurisdiction, wrong court, lack of personal jurisdiction, no jurisdiction over the person sued, improper venue, wrong jurisdiction, failure to state a claim for which relief can be granted, insufficient or deficient allegations, insufficient service of process, statute of limitations, and qualified immunity, where the law was not clearly established at the time of the alleged wrongdoing, leaving the officer to make a bad guess in a gray area.
So look what they did. This is the same stuff you can use against them. Lack of subject matter jurisdiction. We're in the wrong court. Lack of personal jurisdiction. No jurisdiction over my person being sued, my living me. Improper venue. We're in the wrong jurisdiction for this. Failure to state a claim to which relief can be granted. Insufficient or deficient allegations. One of my people got this one when he sued the cops. They're saying failure to state a claim where relief, this is what they always ask for. They ask for it, we can ask for it too. Where relief can be granted. So what they're saying is you have insufficient allegations, or you're deficient in your allegations. Insufficient process of service of process. Process server, things going on, something wasn't done right. Statute of limitations. Here, I think they said 3 years. So if you do it after 3 years, you're screwed. Qualified immunity. This happens if you're a U.S. citizen going after them because you are their property. Their property cannot sue them. So they're going to use all these things if you don't put this in the right court, which for most people is going to be in the federal district court. The state can hear this, but unfortunately, the states are usually in bed with the county or the municipality. So I would take it to the federal court because the federal court is going to stand on your constitutional rights. Okay, let's keep going.
Area. All police officers have some form of immunity for negligence, unintentional conduct.
That's just crazy to me. They have an immunity for negligence. When you're dealing with somebody's life, oh, sorry, I accidentally blamed you in the face. It was unintentional. That's all I have to say is it was unintentional. I didn't mean to do this to him that long. No, you were trained. This is what gets me about these doctors and police officers, whoever else. There's no other job where you can do that. And you're dealing with people's lives, livelihoods, families. A child will never grow up because of some people's unintentional things. And all they have to do is claim it. Well, it was unintentional. Unintentional doesn't excuse the fact. So whereas you could not possibly, in some scenarios, sue on his public side, go after him personally. Because personally and privately, he still did the action. He'd take his house and his kids' lunch money. Take his wife's car. Depending on the scenario. Now, obviously, this is not to be used for illegal purposes or fake liens or whatever else. You're on your own. But these are the facts. That's the facts, Jack.
Conduct. However, there are no state law immunities available to municipal or county police officers against state constitutional claims or intentional torts. The opposite is true for deputy sheriffs, who are immune from constitutional claims and intentional torts absent malice and/or gross negligence. Qualified immunity can be raised against Section 1983 claims, including excessive force claims, but its utility is limited. It is most effective in cases concerning seizures effected by relatively new devices, such as tasers, or searches of new or relatively new technological devices. If a motion to dismiss is filed, the court may deny it, grant part but not all of it, or grant all of it, thus ending the case. If the case proceeds, the litigation then enters the discovery phase. 7. A third party. B. The discovery phase. Discovery is a pre-trial procedure in a lawsuit in which each party, through the rules of civil procedure, can obtain evidence from the other party or parties by means of discovery devices such as interrogatories, requests for production of documents, depositions, and requests for physical examinations. Interrogatories are a formal set of written questions propounded by one litigant and required to be answered by an adversary in order to clarify matters of fact and help to determine in advance what facts will be presented at any trial in the case. Answers to interrogatories are the written response to interrogatories. Each interrogatory, to the extent it is not objected to, must be answered separately and fully in writing under oath, based upon the party's best knowledge, information, and belief. Answers to interrogatories are testimony that can be read in court and used as a tool for cross-examination. Consequently, any police officer who executes answers to interrogatories must be satisfied beyond any doubt as to the accuracy of the answers. Depositions generally follow answers to interrogatories. A deposition is a part of the discovery process in which an attorney for one of the parties to a lawsuit can question the opposing party or a witness under oath. Statements given under oath at a deposition are testimony that can be read in court and used as a tool for cross-examination. Consequently, any police officer who testifies at a deposition must do so truthfully and accurately. Requests for production of documents, Electronically stored information and tangible things are a discovery device that requires the parties to produce documents, electronically stored information, tangible items, videos, photographs, sound recordings, images, and other data or data compilations stored in any medium from which information concerning the case can be obtained. In police misconduct cases, the most important documents were prepared long before any lawsuit was filed. The documents referred to are those recorded or prepared by police officers themselves at the time of the events in question. Examples include body camera recordings, police communications recordings, initial reports, incident reports, arrest reports, supplement/narratives, use of force reports, charging documents, and affidavits in support of search or arrest warrants. Accuracy, truthfulness, thoroughness, and consistency must be the underpinnings of each and every document a police officer prepares. The documents generated by a police agency at the time of the event giving rise to a lawsuit are far more important to the defense than any document drafted by an attorney months or years later. C. Moving for summary judgment. Once discovery ends, pursuant to the court's scheduling order, your attorney may file a motion for summary judgment. A motion for summary judgment is a request for a decision by the court of the matter submitted to it, based upon legal arguments only, where no material facts are in dispute. In other words, a motion for summary judgment assumes that there are no genuine issues of material fact in the case, and that, as a result, the court can resolve the case upon the legal issues only, making any trial unnecessary. Motions for summary judgment generally are supported by exhibits, including affidavits, answers to interrogatories, deposition transcripts, and documentary evidence, e.g., police reports, radio communications, photographs, and videos, including dash cam and body camera footage. 9. An affidavit is a written sworn statement of fact voluntarily made by an affiant under penalties of perjury. An affidavit is yet another form of testimony that can be used in court as a tool on cross-examination. A court may deny a motion for summary judgment, grant part but not all of it, or grant it in its entirety, thus ending the case. Case D. Trial. If all or some of the claims survive a motion for summary judgment, the remaining claims will be tried to a finder of fact, either judge or jury. Preparation and presentation are the keys. In a civil case, the plaintiff carries the burden of proof, which is a preponderance of the evidence. A preponderance of evidence has been described as just enough evidence to make it more likely than not that the fact the claimant seeks to prove is true. It is important at this point to recall that affidavits, answers to interrogatories, and deposition transcripts can be used at trial in many ways, including to impeach one's credibility on cross-examination. Similarly, if a police officer testified in a criminal proceeding related to a police misconduct lawsuit, that testimony can be used in the lawsuit as well. If the finder of fact, judge or jury, finds in favor of the plaintiff on one or more claims, a judgment will be recorded in the docket. The judgment will consist of the liability determination and any award of damages. If a violation of Section 1983 is proven, the judgment ultimately will include the attorney's fees that are recoverable by the prevailing party. Under Section 1983, damages are unlimited. Under state law, the damages recoverable from local governments are limited to $400,000 per individual claim and $800,000 per occurrence. If there was no reservation of rights as to the issue of indemnification, your local government's insurance provider will satisfy the judgment for compensatory damages, as well as any award of attorney's fees, if applicable. Local governments are not liable for punitive damages. There is no limit on the amount of punitive damages that can be awarded against an individual under state or federal law. Depending on the circumstances of each case, the parties may pursue post-trial motions, e.g., motion for a new trial, motion for judgment notwithstanding the verdict, motion to reduce the damages award. E. Appeal. Again, depending on the circumstances of each case, a party may choose to appeal. An appeal is the process in which cases are reviewed by appellate courts, where parties request a formal reversal of some aspect of the proceedings in the lower court. Appeals are not retrials. Instead, they function both as a process for error correction as well as a process of clarifying and interpreting law. Appeals from the United States District Court of the District of Maryland are heard in the United States Court of Appeals for the Fourth Circuit. The Fourth Circuit is the arbiter of federal law for a number of states, including Maryland. The Fourth Circuit Court of Appeals decisions may be reviewed by the United States Supreme Court. Appeals from Maryland Circuit Courts are heard first in the Court of Special Appeals. That court's decisions may be reviewed by Maryland's highest appellate court, the Court of Appeals. 10. Conclusion. Lawsuits against police officers are here to stay. Through unlimited damages for federal claims or increased tort liability limits for state claims, the incentives to sue, including the award of attorney's fees, are simply too great. Since law enforcement agencies must accept the specter of lawsuits, they must be proactive to reduce not only their number, but also the likelihood of adverse results. Holding officers to the highest standards and providing thorough, updated training, including legal updates, in areas such as use of force, searches and seizures, and interacting with the emotionally disturbed and physically disabled, can help. So can technology. The ever-increasing use of car and body cameras is rapidly reshaping the landscape of police misconduct litigation. It is anticipated that police cameras will reduce the bad behavior of both officers and suspects, and the evidentiary weight of such evidence cannot be overstated. In the end, however, it is essentially up to each individual officer to act within the confines of the law and in accordance with departmental training, policies, and procedures. Having done so is the best defense to any lawsuit. By John F. Breads, Jr., Director of Legal Services, Local Government Insurance Trust.
Local Government Insurance Trust. Interesting how all these people and large entities move in trusts, wouldn't you say? But anyway, guys, I hope you enjoyed that particular bit of information. Let's see here. Okay, so once again, that particular bit of information was by the Local Government Insurance Trust. It is considered fair use and out there on the internet, so you can download it for yourself. There was no made mention of this being confidential, or it could not be, utilized on, YouTube. So if you want to get it, look it up for yourself. Otherwise, yeah. So that's it. So this segment was just really about when a police officer, when police officers are sued, an overall police misconduct litigation report. So that is it. Hopefully you guys found that interesting and some new bits and pieces of information. And I will talk to you later. The wolf is out. Go enjoy yourselves. Stay warm. Get yourself a Badwolf hoodie or hat. Where's my hat? Well, at least I got my hoodie. It's only because I'm single right now. Otherwise, girls normally steal hoodies. So pretty safe. So go get yourself one, blackside32.com, or go on my spread shop and get one there. Otherwise, that's it. Take care. I will talk to you guys later. Stay warm, stay wise, stay aware, stay woke, if you will. And by that, I mean, don't fall for the whole, how should I say, the propaganda machine that's out there. All right. Be your own individuals and take care of yourselves. Till next time, we'll be back in 2 and 2.